Looks like everyone is ready. We are now here for the case of Hills and Dales versus Iowa Department of Education. And Mr. Kane, you may begin.
Madam Chief Justice, honorable members of the Supreme Court, Counsel, may it please the Court. My name is Brian Kane. I represent Hills and Dales Child Development Center, the Executive Director and the head of the ABA services are here with me today. This case, the department, the district court, community school district, and the AEA would have you believe is about legal issues. I would submit to you that this is about elementary school students, middle school students who have autism, who are served by Hills and Dales. And
Going to ask about the record. Hills and Dales does not provide an educational component, is that correct?
Hills and Dales is an Iowa nonprofit corporation licensed by the Department of Human Services, CMS. I have a whole litany of their qualifications in our brief. In the interest of time, I won't go through it. But suffice it to say that it's in the residential care, outpatient kind of treatment care, and for some of the most medically fragile, intellectually fragile people in our society. They do an excellent job. They are legally bound by their licensing to follow physician orders, and that's going to be a key component of this today, of this argument.
That work at Hill and Dale, are they physicians?
The actual employees of Hills and Dales, the ones who provide the ABA services, Your Honor, they are not physicians. They are what's called BCBA professionals, board-certified behavioral analysts who carry out the ABA services. In the record, I believe it was page 46 of the appendix, there is a letter in the record from the physicians, the pediatricians of Medical Associates in Dubuque, which states, among other things, that, and you've seen this, it's in the record, you can read it, but they say the physicians at the Medical Associates Clinic state that ABA therapy is the gold standard for children with autism spectrum disorder. It is a medical treatment. That's important. The experts in the case are saying that what they do is a medical treatment prescribed by a physician for eligible patients. When such a therapy is prescribed, an authorized caretaker, such as Hills and Dales through its autism services department, is expected to follow the physician order with parental or guardian consent. ABA therapy should be provided by licensed board-certified behavioral analyst professionals. One thing we need to make clear, I could hang out a sign that says I'm going to provide ABA treatment, but I'm not board-certified. I don't have the professional qualifications licensure. This becomes critically important when we talk about the IDEA, the Individuals Disabilities Education Act.
I worked with Sue Seitz on the Garrett F. case, and that we lost to the Shuttleworth firm. And I mean, I'm quite certain that Garrett F. Had some kind of prescription for the very, sophisticated services that this poor ventilator-dependent kid needed to get through the school day. But and we argued, long and hard that those were medical services, and we lost. And the Supreme Court said, if it's not provided, it's a bright line rule. If it's not provided by a physician and it's not a diagnostic or evaluative service, then it's considered a related service, and it needs to be, part of the IEP and provided by the school and so forth. So, how do you get around that case?
I think I'd get around it by citing the actual statute itself. The provision of, find it here, it's that subsection 26 that has the litany of the things that are defined as related services, does not specifically include ABA treatment. And the physicians, the experts in our case, have said that it is a medical treatment. And we have the Third Circuit case that rejected Garrett. And despite the DOE position that we can't consider it,
Maybe they rejected Garrett, but they weren't supposed to. It's the U.S. Supreme Court. They're not supposed to reject it, and I don't think we can, right?
the Sweet case, State v. Sweet, you are only bound as a court, your case, you're only bound as a court when the decision is an interpretation of the federal Constitution, the way I read the decision that you made in that case. This is not that case.
Surely. We're bound by United States Supreme Court interpretation of federal law and accompanying regulations.
True, but you also have said that in the development of our own state constitutional analysis, we may look to decisions of the Supreme Court, cases from other states, and other persuasive authorities. We're submitting to you that Mary T. from the Third Circuit is other persuasive authority. And it,
A little bit. Let's just assume, for argument's sake, that we need to follow the case of Garrett, and just assume that for purposes of this. I'm a little confused. I consider myself to be pretty savvy on the issues here in particular, and I don't quite understand. Am I correct, and you can correct me if I'm wrong, am I correct that in your facility, in your client's facility, whoever receives ABA and is still of mandatory attendance age, some kids or students might have it on their IEP, others may not. Am I correct? It doesn't seem to be much of a rub. It's the cases where they're not on the IEP, would that be, or the, part of their FAPE.
if I understand your question correctly, the situation here is the IEP is not including the ABA treatment provided by Hills and Dales. As a matter of fact, okay.
Students we're talking about don't have ABA on their IEP, or their FAPE. We've got all these acronyms.
Have a doctor, okay, all right.
Talk about the educational component only. It's not on their IEP for some students, am I correct? And aren't those the ones we're kind of talking about that are the rub?
We are.
And if it's on their IEP, they're going to be excused from the school, or that'll be part of the school day to acquire what they need on their IEP. Would that be correct?
EP, it's the community school district itself saying that it can provide these services, not my client. Not my client, right.
Follow up to that, please. Just in layman's terms, why don't you explain to me the practical import of the decision below? And I think you started your argument maybe going along those lines where you said this case is about students. So what is the end result here in terms of practical terms that your client is objecting to?
Who should decide medical treatment for the students who are in the charge of Hills and Dales, and how should they do that? If those persons, those fragile persons who are students in the Dubuque Community School District because of FAPE, who should decide what treatment they get? I have a healthcare Department of Human Services, CMS organization dedicated to providing meaningful lives for these people who have a legal obligation to adhere to physician orders on the one hand, and I have an IEP and a community school district guided by the AEA saying out of some concern that some parent will sue somebody for their student not being in school enough, that they should decide. And there's a whole litany of things in here about who should.
Go ahead, Justice. Can I have one follow-up?
Doesn't the parent get to participate in the formulation of the IEP?
Who?
Right of appeal, they can go up to the AEA if they don't like it, and, I mean, because it's not like the school unilaterally makes these decisions. The parent gets to participate.
To you that if there's a doctor order that says this particular student, and we need to get granular about this. This needs to be student by student. This is not some just legal question. If the physician says this treated student or treated resident needs this particular treatment, that should be given not just some weight, but great weight. And it was not.
Example. So you have a student who needs ABA therapy. And I guess the conflict then for you, am I right, is whether or not the school can provide the therapy when Hills and Dales would prefer to provide it.
Your Honor, I would not agree with that because I can't concede that the school can provide the same intensity, the same consistency, the same professional treatment, even if they have BCBAs on staff. This is a year-round.
Is you believe your client can provide better services than the district, and that is what you're objecting to. That's the practical consequence. Okay.
It was like my comment before. I could hang out a sign, Brian Kane, ABA treatment. That doesn't have any meaning.
You guys can provide that better. Isn't that a fair argument? What's good for the goose is good for the gander, and they are better at providing education and what's necessary for theirs?
They better, we're not even licensed to do it. We don't provide education. That's why the residents, there's several students who actually reside at Hills and Dales in the facility who
Been made, I believe, something about maybe the easiest solution would be provide what you need to provide before or after school. And I think everyone, according to the briefs, acknowledges it helps these kids get through the day to endure. Isn't that an argument that it's a service and not so much just for the medical purpose, but actually an academic service?
There's a lot of discussion about the fatigue factor in all of the briefs. So it's impractical to have end-of-day decisions.
Towards the educational component of it?
I don't believe, first of all, that it is a related service. We're arguing that it's a medical service. A medical service.
Before or after the school day?
I think the school day in the record starts at 6 or 7 o'clock in the morning and goes to 6 or 7 o'clock at night, and then there's activities afterward. There is simply, we're dealing with.
I don't know of a school day like that. 5 days a week?
I mean, remember, these are people who are medically fragile, living in a facility, who have to have a lot of duties in the morning to get up and go, and I'm sure you know that. So the experts are saying that there is a fatigue factor here, and what's troubling is that if you're a parent who can handle dual enrollment, and the school district approves of dual enrollment, which has happened a couple of times, you can homeschool and then do the AB services then. But since Hills and Dales cannot provide educational services, and it's in charge of those students who actually reside at the facility, they cannot do dual enrollment. So those students aren't able to either get out or I'm sorry.
I want to go back to the process questions that were being explored by Justice Mansfield. And let me state a couple sentences and then get your response. But it seems to me an argument could be made that the proper forum to determine whether ABA therapy on school time should be provided or not should be decided by the individual educational program process. The parents can weigh in. If there's a letter from you folks saying this kid really needs it, that should be given substantial weight. But the school district ultimately makes a decision, or the school authorities make the decision for the IEP, and the parents can appeal it if they don't like it. And maybe they can get it reversed if you have a strong letter from you folks talking about the services. Maybe it gets reversed. Why isn't that the process that the IDEA requires?
We are not arguing that Hills and Dales should decide itself. We are not arguing that there shouldn't be an IEP process. We are arguing that Hills and Dales does not have a voice at that process. Parents do. Not all parents are capable of advocating for themselves in a way that might be best for their students if we look at this practically. That this is a room full of professional educators. Sometimes there's up to 20 people in the room for an IEP, and it can be very intimidating. Some parents, unfortunately, because of economics or other challenges with other children in their lives, aren't able to homeschool, aren't able to dual enroll.
Argument for those parents, but you're representing Hills and Dales.
But I'm here because Hills and Dales sees this going on, and Hills and Dales has not only a legal but a moral obligation because of its licensing. Its whole purpose is to provide a meaningful life to the people it serves, to make sure that they get the best that they can get. And when they receive, if they ignored the medical associate's letter, they could lose their license. So they are advocating for the student that's in their care, and they're bound to pursue it. We're bound to be here.
We've got a red light there.
Sorry. I'll come back at reply. Thank you.
Ms. Esbrook?
May it please the court, counsel. Good morning. My name is Jordan Esbrook. I work at the Attorney General's office. I'm here this morning representing the Iowa Department of Education. So we are here today on judicial review of the department's declaratory order. And the legal question that you have is whether the department erred in its statement of the law in response to the questions brought by the Keystone AEA. But this case is also about children with disabilities and whether they get to go to school every day like every other kid in Iowa. The statutes that the department interpreted in its declaratory order encompass very important policy decisions that we have made through the Iowa legislature and the United States Congress. And that's Iowa Code Chapter 299, which is our compulsory attendance statute, and the Individuals with Disabilities in Education Act, previously known as All Handicapped Children Act from 1975. So the compulsory attendance law is something that every state has. We've had it here in Iowa since 1902. And it's a decision that the most important thing that kids can be doing during the school day is going to school, even though there's lots of other things they can be doing. School is where they socialize. School is where they learn skills to be independent when they grow up. School is where they learn to get along with people who are not like them. School is where they learn to be citizens. And so we have decided as a community that this is an important thing for them to be doing. Yeah.
Petition's letter, that is well documented and says, look, A, we offer ABA therapy. B, given the test results and baseline of this individual student, this therapy will not be effective unless they are released during class time. I'm making the hypothetical, that this therapy will not be properly given after school because of the fatigue factor, whatever. And that it's critical for this child that ABA therapy be provided on what I'll call a release time basis. Am I communicating with you? Oh, yeah, okay. So assume that kind of letter comes in. How's it treated? What happens?
Right, the declaratory order says what happens is this needs to be determined at the district level in the IEP process. So there's no individual kids whose rights are decided in this decision, but if in that hypothetical, the IEP team includes the parents, it includes the classroom teacher, it includes the special education teacher, and the parents can bring in letters like that. They could even bring in a provider if that was something that they wanted. That does happen. And so the decision would be made to develop a plan for that student, all the education and special instruction that they might need, the related services that they might need. ABA therapy is a related service. It is something the district can offer here in Dubuque, and so that's in the record. So in that case, if it needed to be offered during the school day, it would be part of FAPE, and it would be offered by the school. And so if it's part of FAPE, it's...
By the school.
The school employs professionals to assist its students with special needs. The Dubuque School District does employ individuals who are qualified to provide ABA therapy. And so that is something that they could be pulled out of the regular classroom to have provided for them during the school day. In addition to, oh, sorry.
Let me just ask about the money, the dollars. So
Okay.
If it's part of the IEP, I mean, the school district is obligated to, part of FAPE is free. Okay?
Free.
So if it's in the IEP, the school district provides it to the parents, right?
That's correct, Your Honor, without charge, yes.
But if it's what they're proposing, the school district isn't responsible for that. Who pays for that? Is that Title 19, or who pays for their service, Hills and Dales, under the scenario they're talking about, where they just have a doctor's letter and they're excused?
Funded by Medicaid. I'm not entirely sure, Your Honor. I know the school funding process better.
It seems to be kind of the opposite of Garrett. In Garrett, the parents were trying to get the school to pay for the services required so that their child could go to school. In this case, at least from Hills and Dale's perspective, it seems like the IEP process, by including these ABA services as related services, that necessarily then means that the school is the one that provides the service. And so if the parent would prefer for Hills and Dales to provide those services, by making it part of the IEP process, that takes that ability away from the parents.
Ability away if they need to have it during the school day. I mean, it does, if it's something that they want to provide either because it's not part of the IEP or it's in addition to services they're receiving at school, then it needs to happen outside of the school day. And that's true because it's mandated by law and important for the children to receive their education. And the school district's position, and the department agreed, is that the school services should not be the services that give way.
I think the record indicated, I think I saw this mentioned in the briefing, that some parents or some kids have a school day that's shorter than the regular day that would enable them to go and attend a place like Hills and Dales, the kids.
IEPs can include a shortened school day. And again, it's hard to know exactly what these kids have. The record wasn't made. This wasn't a contested case, and the parents and kids were not part of the case. They didn't appear before the department. But it does appear from the record that some of them do have shortened days, and that's a potential solution.
Included a shortened day, would that allow the student to go and receive the ABA services from Hills and Dales? Or would it, if it's part of the IEP, does it have to be provided by the school's ABA providers?
In general, I think since the school is able to offer it, it would happen during the school day. The IDEA does permit the school to hire other providers to provide services that they either can't provide or think need to be done somewhere else for whatever reason that's individual to that particular child.
Controlling here on the issue that it has to be a physician providing the services, otherwise it's a related service.
Garrett case does control. I know the State v. Sweet case that we cited is a constitutional case, but the court has decided in other circumstances that in federal statutes, federal law does control. I will say, as far as the issue of the school's discretion to determine a policy for excusing absences, it doesn't really matter what they're gone for. The point is they're missing their instructional time for something that is not part of their school day. So it could be, when you get into medical services, I know the question has come up, what if they needed chemotherapy? If they're not able to come to school, they'll be excused, right? That's a different question. But I think the fact that ABA therapy is a related service that the school can provide means they need to be even more cautious about excusing kids for having that outside of school time, that they would be denying those kids FAPE.
Additional funding from federal or state sources for providing the ABA therapy in-house?
The school does receive federal and state funding for providing special education. I don't think there's a specific budget for ABA therapy, but I am not sure, Your Honor.
Speech or OT or something. And so imagine this scenario, same set of facts, but not in a community the size of Dubuque, where you have, the ability to provide the ABA services. Imagine it's in a rural community where they may not even have speech pathology. They may have to have all of that brought in. How would this case look different? Would your argument be any different if it were in a community that could not provide ABA through their schools?
Would be the same in that it is the school's responsibility to make sure the services that a child needs for FAPE are provided to that child. If it is not something the school is capable, because it's a small district, of providing in-house, they would have to bring somebody, perhaps Hills and Dales, perhaps another provider, to give that to the kid and make sure it is in a way that works for that child. But the legal responsibility and the structure of the IDEA would remain the same.
Besides the content of the IEP in the event of conflict, I mean, it's ordinarily a consensus process. I think we all know that. There's multiple people and multiple inputs and so forth. And it's kind of an interactive process with the parents, try to work it out, and probably in, I don't know, a large number of cases, you reach consensus and that's it. But supposing you're not able to receive consensus and you're not able to get a consensus on the ABA therapy release time issue, who ultimately has the authority to say, I'm sorry, we've exhausted our processes, we haven't come to agreement, this is the IEP?
School does, Your Honor, but there are procedural safeguards that are in place in the IDEA for parents. They have rights, and those include requesting mediation, which can result in a binding mediation agreement with the school. It includes filing a due process complaint, which results in an evidentiary hearing. It includes an independent educational examination of the child, and it can also include filing what's called a state complaint with the Department of Education saying, hey, this is what I wanted, I didn't get it, this violates the IDEA in my child's case, and I need you to look into it.
I asked opposing counsel, is this case about, there are kids who have a prescription for ABA therapy, and some of those kids have that treatment on their IEP, and others do not?
That's part of the situation that brought us here, Your Honor.
Let's talk about the kids who do not have it on their IEP. Are you aware of that? If it's, how is it brought to your attention by Hills and Dales? Is it brought to your attention by parents? Can you give me an idea of the cases where it's not on the IEP? Why would it not be?
I don't know, Your Honor. The record doesn't really show that, again, because that's a decision that needs to be made at the district level, and what we're talking about here is the legal structure. So there is, what we have in the record is some statements from parents that they like ABA therapy. There's some kind of bullet point summaries of what some kids are receiving. But if there are particular kids who have a prescription for ABA therapy, it's not in their IEP, and that's the kind of unresolvable tension. I'm not sure what's happening with those individual kids. Just it's not part of the case.
In their IEP, you're saying the legal structure is then it needs to happen outside that school day?
Part of the IEP, and it's something the parents want and say they've gone through the appeal process, and the end result after that is still the district says you don't need this, then yes, they would have to get that outside of the school day.
To modify the IEP?
I believe, has to be reviewed annually, and it can be reviewed for other reasons. So if things change and they say, look, this isn't working, the IEP is not working.
I know about ABA therapy, conceivably, and all of a sudden, maybe 3 months in, and all of a sudden, maybe the parent may determine that things aren't working that well for their child. They discover the therapy and they want it. The avenue for modification is what?
It's a kind of ongoing interactive process between the parents and the school. So they would start at the school, request a meeting with the IEP team, bring this forward and say, look, here I found something that I have heard is really helpful for kids who are in my child's situation. It's considered the gold standard. It has these results in behavioral improvement, and I want to try it.
Legal structure, but I'm trying to wrap my head around why we're here. Am I correct that there are kids who need services, parents who have been informed of those services, and parents who choose, maybe for purposes, maybe they think they don't want the stigma, for example, of their child being on an IEP or having certain services in their IEP that pulls them out during a school day. Is that any part of the structure of perhaps why it's not in an IEP?
I think the children that we're talking about here are all eligible for special education. It sounds like they, especially the ones who reside at Hills and Dales, have some pretty serious care needs, and that's why some of them can't live at home, at least for a period of time. So I think all of these students have IEPs, and they are coming to school and receiving special instruction, as well as general.
We'll be deciding this case not just based on ABA. I would think that whatever this court decides, you could read it in terms of any medically prescribed therapy or treatment that may not make it into an IEP. It could stand for anything. So maybe somebody doesn't live in a facility, but am I correct that there are sometimes those cases where it may not be in an IEP, either by the parent's choice or concern for stigma?
I think one of the reasons that we're here is there's kind of a hole in the law as far as parent choice for what's called competent private instruction or independent private instruction. And maybe that's where you were wondering about, Your Honor. So a parent with a child who's living at home and is not eligible or hasn't been identified as needing special education can choose competent private instruction, which would be taught either by the parent or a licensed teacher outside of school, but that child can dual enroll in the district for music, art, sports, or special education services. So they kind of the parent has some flexibility in choosing the best of both worlds, and that child could use the time they're not in school for homeschooling, for religious education, for Hills and Dale services, for example. Or it might work in a case, where a child has medical needs and they can't be there all day for whatever reason. The children who reside at Hills and Dales are in a little bit of a legal pickle in that regard because their parents don't live at the school and they can't teach them. And Hills and Dales, as we started out with today, is not a school. It doesn't employ any teachers. And so the Department of Education is bound by the law as it is now. But that is something I think perhaps the legislature could address in the future. So I think I'm almost at, I am out. That's the red line. Yes.
Deference do we owe the Department of Education's decision, especially since the fighting issue seems to be over interpretation of federal law?
Well, the Department of Education deference on its interpretation of federal law. The department is charged with interpreting Iowa school law, and that would include the compulsory attendance statute. But I don't think the case turns on that, whether you give them deference. I think even if you're reviewing us for correction of errors at law, their decision was correct. Thank you so much.
Thank you very much. Three brief things. One, this isn't, you saw the letter in the file in the record right after the physician letter from the county attorney under 299. He opined this was a reasonable excuse. So the whole DOE, we're worried, and Keystone AEA, we're worried about truancy. You know, that seems to defy common sense, at least to me. Secondly, I think that the DOE, the AEA, and the school district are ignoring that this is not a permanent situation with the ABA treatment, that it's temporal in nature and sometimes short-lived. And the record shows that there were a significant number of students, measured by how many there were when this matter started, who didn't miss any school time. So it's, you know, it's not everybody that's being pulled out of school or missing school time, but those that are.
Concern defies common sense. Are you saying we should look the other way for special needs?
Absolutely not. I think what the county attorney was telling us is that when he sees an expert physician opine that this treatment is needed, that he, in his discretion, would believe that's a reasonable excuse from attendance. I'm saying actually the opposite of your question, Your Honor, that we don't look the other way. We look exactly to what's the situation. And that's a case where an expert on truancy, the one who would enforce truancy if somebody brought it to them, is saying that the doctor letter and the care, the ABA treatment at Hills and Dales is appropriate. And I think that was given, in our view, absolutely no weight in any IEP, even less than the physician order.
Through the declaratory order itself, which provisions specifically do you think are wrong? I mean, as I read the order, it essentially says there's kind of a statutory process. It depends on the particular facts and circumstances of the child at issue. The school district has the obligation to comply with federal law, and it'll do it on a case-by-case basis. I think all of that seems correct to me. So which of those conclusions do you think is incorrect?
When the IDOE said that a public agency that excuses a child for therapy may violate the IDEA if the services required by the IEP are not provided because the child is being withheld from school for private therapy, they ignore that it's doctor-ordered private therapy. And I think our concern is that in the IDEA, instead of being used as the law of the land, as a tool to provide FAPE to challenge students, to students with disabilities, it's actually now being used as a sword to deny outside treatment, albeit short-term.
A case-by-case basis. I mean, the facts, conceivably, I mean, and I've been working on this hypothetical, as you know, conceivably there might be a set of facts that are very compelling that A, the treatment is required, and B, you just got to use release time. I mean, I can envision a physician's report that is just really powerful. Well, then the IEP team better pay attention. And if they don't, they may be challenged and may be legally insufficient. But isn't it a case-by-case determination?
I agree that it's case by case, and to take that to here, this is emboldening the IEP to sort of ignore the physician-prescribed ABA treatment.
So that's paragraph C in the conclusions of law. It says the agency may violate the ADA. Doesn't say it will. Doesn't say it will not. It's just stating a legal conclusion that depending on the particular facts of the case, there may or may not be a violation. Why is that legally incorrect?
I don't think it's sufficiently encompassing. It doesn't talk about the standard that we have to reasonably calculate that we're supposed to take action reasonably calculated to enable a child to make progress in light of the child's circumstances. So it doesn't, it's seemingly saying that we don't have to give great weight to hills and dales, fine. We don't have to give great weight to a physician, not fine. We don't have to give much weight to the county attorney. And it's handing, I believe, too much discretion to the IEP. They don't have guidance sufficient to know what to take into account or not. And I don't think the system should depend on forcing parents who aren't all capable of taking legal action into appealing or whatever. I mean, the fact is, there are some students who have a shortened day, but some do not. There's no standard. There's no, it's all ad hoc. I understand individual decisions, but there should be some standard against which you measure those individual decisions. I appreciate it very much, and I thank you for your attention, and would hope that we can get granular and look at the real issue here, which are the students. Thank you.
Hills and Dales versus Iowa Department of Education and AEA is hereby submitted, and court is adjourned for the afternoon.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.